Good morning. Welcome back to my docuseries on how fathers can win their custody case. I am Father X. Let's get to it. Do you think family court lawyers stink? I bet you do. But what if you could smell it from a mile away and overcome it? This section of the docuseries is choosing an attorney. In future sections, we will discuss how to be nice in court, the best interests of the child, your mental preparation, how to prepare for your forensic evaluation, and I will help you prepare your trial strategy. And this section, choosing an attorney, has 4 parts that you need to know that I wish somebody taught me early in the trial process. Choosing your family court lawyer is what we discussed in episode 3A, and it had many interview questions you can ask potential lawyers. The weakness of family court lawyers is what we'll discuss here. And next up, coming soon, are spending on family court lawyers and the secret hidden costs of family court. As I talk about the weaknesses of family court lawyers, I'm only focusing on family lawyers and not all lawyers. And I'm doing this because for you to effectively have a custody decision for the best interest of your child, you have to know the practitioners in family court and their strengths and weaknesses. This knowledge can help you achieve a positive outcome for your kids. A key question for you is, why would I spend so much money on a lawyer charging me $300 an hour if she has these major weaknesses? A second question for you is, if the mother's lawyer has these weaknesses, how do I take advantage of that in my custody case to prevent the court from making bad custody decisions about my child? Many of you are just like me. You know the difference between doing a competent versus incompetent job. I've had a long career with Fortune 500 and smaller technology companies. I'm in finance and accounting, and I manage teams of people. I've interviewed hundreds of job candidates. I evaluate employees to assess their talent, intelligence, and ability to solve problems. I have annual audits where an independent accounting firm audits our books to prove we're doing our job honestly. I create presentations for the board of directors or external investors, where thorough analysis is an absolute requirement. I've worked with dozens of corporate lawyers on a variety of legal matters. I've also created new business processes that have to work effectively. Bottom line, my job is learning facts to solve real problems with real solutions. And if I do that poorly, I have real consequences. I applied that professional background during my years in a family court trial, and I studied the players in this arena. I discovered the complete incompetence of judges, child support magistrates, and family lawyers. Of the over 30 people that I interacted with in family court, 15 were lawyers advising me or the mother. And yes, she had that many because she kept switching. I would never recruit any of these 30 people to work in any organization I worked with, not even in the Office of General Counsel as one of our attorneys. And it's not the case that 100% of lawyers and judges have these major weaknesses, but given how many family court employees and lawyers I interacted with, I estimate that 80% of lawyers have these flaws. Here's what I found are their major weaknesses, and I'll use specific real-life examples throughout this docuseries so you can see it in action. First, little knowledge, even less intelligence. Little depth of analysis. Laziness. Reliance on cliches and marketing slogans. Focus on making clever but untrue statements. Lying in court. Lack of character and integrity. Lack of accountability. Good public speaking but little intelligent thought. Inability to overcome false allegations and a judge's bias against fathers. As I mentioned in episode 1, the introduction, you have to have a specific mindset in family court, and I'm teaching you how to think about and evaluate this new world. Let's get into these to help you detect them as they happen and create a strategy for how you'll use their weaknesses to your advantage. Before we do that, please share your comments below so that other fathers can learn what to expect. Are most family lawyers incompetent? What have you seen? To start, let's make sure we're on the same page on the difference between knowledge and intelligence. Having knowledge means that you know facts about a topic. But intelligence refers to when you don't know about a topic and you start learning about it, gathering information, asking questions, and using your brain as an engine to process that new information. And then you end up with a conclusion or insight of what reality is. Many people call it brain power. And I'm sure you know people who have this ability and others that don't. Well, presenting a strong case in family court requires knowledge of the written laws and statutes, knowledge of case law, knowledge of the actual facts of this case, while weeding out the false allegations. Your lawyer might have the first two, assuming they're a decent lawyer, and you can learn them too. But you have the third one, which is the most crucial. For example, it's in the best interest of the child to live with a parent that can best promote that child's education. Your lawyer may know this simple concept, but that's worthless by itself. You are the expert on how much you read to your kids, do homework with them, and meet their teachers. So your facts are crucial. Your lawyer is useless without them. And I tend to believe that you can learn the law better than the lawyer can learn your facts. You have one case, your lawyer has many. So she will almost never know your part of this equation as well as you can learn her side of the equation. And intelligent analysis requires you to take the facts of your situation and show how they match the law. And it requires that you use the facts of your situation to disprove the false allegations you will likely face. And I'm willing to bet that you can do a much better job than your lawyer. Why? This chart illustrates the general incompetence of family lawyers and judges. I want you to visualize the level of the people that are now making decisions about you and your children. You know that some people are tall and some are short. You know that some people are fat and others are skinny. We're not identical. The same goes for intelligence. Now, we can't take the 300 million people in the United States and force them to take some imaginary, perfectly accurate intelligence test, and then rank them all in terms of intelligence from 0 to 100. That's obvious, but that's not the point here. I'm illustrating for you the relative intelligence level of these family court practitioners compared to the intelligence level that I've seen in people throughout my life and career. Assuming the most intelligent people are at the 100th percentile and the least intelligent people are ranked at the 0 percentile. As I met over 30 people in family court, like lawyers, judges, child support magistrates, children's services, I assessed them all to be within the range of 20% to 35% of intelligence. As a group, this is their cultural norm and where these people rank. Of course, clearly there are exceptions and maybe 10% of them are in the top 50% of intelligence. But as a group, this is what you're facing. If you've been to family court several times, then I'm sure this makes sense to you. I estimate that a full 65% of Americans are smarter than most family court lawyers and judges. If you're in this top 65%, you should use that to your advantage. I'll teach you how to use this with the docuseries. Unfortunately, if you think you're in the bottom 35%, you may be just at the same level as these folks. But I don't believe that makes you a second-class citizen or a bad father, and you should not have your parental rights trampled by these incompetent people. So this docuseries is designed to also help you overcome the incompetence and gender bias of family court. Here's an illustration of how family lawyers generally argue as opposed to a competent professional. It shows how they present partial truth instead of total truth in order to deceive an uninformed person, like a judge, since judges don't actually even know the two parents. Let's assume I want you to invest in my business. Let's assume this is just a one-time project with no revenue or expenses in future years. In the first example, I'm presenting you a simple business case. If I told you the whole truth, I would tell you that revenues are $1,000, expenses are $1,400, and the net income is a loss of $400. I would tell you this entire story to inform your investment decision, just like when a judge is making a custody decision. Since this business is going to lose $400, there's no point for you to invest because you can't be paid back on your investment. It's obviously a bad investment. Now, here's what a family court lawyer would generally do when they argue in court. Here, a lawyer might say, "This is a great investment opportunity. You should invest. We're going to have revenues of $1,000. Because you're only being given a partial story, you might be deceived into thinking this is a good investment. In this other example, a lawyer might say, "This is a great investment opportunity. You should invest. We're only going to have expenses of $1,400. Again, you might be deceived into thinking this is a good opportunity because the lawyer is hiding the revenue and the net loss. The same holds true when lawyers present their cases in court. They'll pretend the mother should be the primary custodial parent with 2 to 3 bullet points, when in reality she's not, because they didn't do the complete analysis to prove it, based on the total best interests of the child. In my line of work, if somebody came to me with this half-baked analysis, I would throw it in the garbage. To me, it reflects a lack of integrity and competence. But in family court, this is routine and tolerated. Some lawyers even think they're clever when they can sell the judge on a false storyline. This is where you can easily see the gender bias of family court judges, when they just believe whatever hack job analysis the mother or her lawyer are presenting, without question. The bias is extremely transparent. Usually, dads in our situation get angry because this is absurd. Anger is justified. I got angry. But public anger gets you nowhere. Instead, you can overcome this incompetence by presenting a complete analysis, showing that the total of your positives and negatives outweigh her positives and negatives, such that you should be the primary custodial parent. In my case, it took me 28 hours of testimony over 14 court dates, more than a year, to chip away at the hack job analysis and lying of the mother and her lawyers. That's why I won. And I know you're thinking, why do I have to fight so hard? And why can't the judge just be fair? I know, you're correct. We can't change the behavior of judges. That's why we should just fire them and create a new system. Until that happens, since I know what you're up against, I want to arm you with the best strategies so you have a shot at being treated like an equal human being. Earlier, I mentioned public speaking versus intelligent thought. Most lawyers in a trial setting are very good public speakers. Lawyers often follow the standard playbook, emphasizing 3 to 4 key points instead of overwhelming the judge with 20 points. And their conclusions appear authoritative and accurate. This can be intimidating. However, a competent professional would state all the pros and cons of the mother and the father, and they would show that, in total, one parent might be better than the other one. In the legal world, that's called the totality of the circumstance. Intelligent and complete analysis can defeat good public speaking, especially when you go one step further and you portray that speaker as trying to manipulate the court by hiding the total set of facts. With regard to laziness, you can have an advantage against your opposing lawyer's laziness by working harder than everybody else. With their use of cliches, you'll hear, "A child needs its mother. This is a nurturing and caring mother. The father is just not involved with the child. The father is just too abusive and too risky to put with a child. The father doesn't know how to change diapers or feed the baby." And yes, I'm using that voice because that's exactly what those people sound like when they speak. So here, lawyers tend to use these arguments like 7th graders who just joined their school's debate team. Basically, they don't have any completeness of thought and rarely bother to research real facts. You can overcome this by holding up their statements for the judge to clearly see, and then showing facts to prove the attorney and the mother were intentionally trying to manipulate the court by using these cliches. You should always humiliate the other lawyer by publicly pointing out when they are being deceitful to the court. Just do it as a matter of fact, without anger. Lawyers hate being exposed that way. Trust me, I've done it. When I mentioned accountability as a weakness, it's because family lawyers go through dozens of clients a year. If she loses a custody case, that lawyer still gets paid and there's no accountability for her bad work performance. She doesn't have to deal with any consequences for a child being with one parent or the other. The lawyer moves on. Even worse, none of this is public, so if the lawyer is incompetent, most new clients would have no way of knowing. When you have zero accountability, it breeds incompetence. That would be rare in my line of work, but it's common in this industry. The next topic in this docuseries will be spending on family court lawyers. These might be the darkest days of your life, and I'm making these educational videos to help you navigate this nightmare. If you subscribe, I can get you updates when I post more videos in this docuseries. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position.